If your spouse gets remarried, how can you protect the assets so that you ensure that they stay in your family? Hi, I'm Claire from the Yanowitz Law Firm, where we've been helping families protect what matters most for the last 30 years. Okay, let's get started. So, a common question or a concern that I have when I meet with clients is, okay, you know, we're married, one of us is going to die in the future and the other one is going to be left. And what if they get remarried? What's going to happen to the money that we have earned together as a couple? We want to make sure that property passes to our kids. It doesn't go to a new spouse. And sometimes people have brought up to me, they'll say, well, we're totally on the same page. We agree to it. But sometimes as people get older, they might decline mentally. They might be taken advantage of. They essentially could get remarried to someone who forces them to do something and could destroy the plan that we have put in place. Or they could get divorced from that new spouse, and that new spouse could take a lot of their assets. So what should we do about that? My response is that oftentimes it can be helpful to pass assets to a spouse in a trust instead of outright. That can help alleviate some of these concerns that I just mentioned. So a nice thing about having your spouse inherit in a trust at your death instead of outright is this trust can indicate, okay, well, anything left in this trust at my spouse's death, it's going to go to our kids. So you're assured it's not going to go to their new spouse. It's not going to go to their new spouse's kids. It's going to go stay within our family bloodline. So you can set it up so that it's going to pass that way. If your spouse inherits in a trust and then they later on go get remarried and divorced, the assets in the trust are much less likely going to be subject to division in the event your spouse gets divorced from their new spouse, okay? So that it can be helpful. It can act as protection from them being part of a divorce proceeding. Now, if your spouse inherits in trust, it also can make it harder for, if they were to die, I'm married to Jim and then Jim gets married to Sally after I die and then Jim dies, okay? In Minnesota, there is something called the forced share, the elective share, and it's the minimum amount you're required to leave a spouse at your death. And the share increases the longer you've been married. And so when Jim is married to Sally, he dies. If Jim just inherited outright from me at my death, it's more likely that Sally can kind of elect against the assets he received from me at my death. So she's more likely to stick her hands in the honey pot of what I gave him at my death. Whereas if it's in a trust, it becomes a lot harder to kind of attach to it that way. Also, if your spouse inherits in a trust and they aren't able to kind of take the assets out of the trust as easily, it can make it so that they're not able to kind of dish it out to their new friend, to somebody else, somebody who's kind of taking advantage of them. So whenever we're setting up these trusts, then we have to have kind of the conversation of how loose or how tight do we want to make the trust. So a really loose trust would say, my spouse can take this out for any reason, at any time, at any amount, very broad, flexible, liberal standards. We don't care if this trust is spent down during their lifetime. A kind of a more narrow trust would say, okay, yes, they can get into this trust for principal, but we need to use assets in their own individual name first at their death. Yes, they can alter where this passes, but it has to stay within our family. So that would be kind of like a middle of the road. And then like a really tight trust, which I see more of these in like second marriages or blended family, will basically say, spouse only gets the income. Maybe they get a percentage amount, so they get the greater of all the income, or 4%. So they get like this allowance all the time from the trust, but they can't like go into it and take out all of the trust at once. They just get, 4 or 5% a year. They can't touch the rest. Maybe they can only touch the rest if they've used up all the other assets, if they really showed need. Those are all things to consider at my spouse's death. This trust must go to my children. They don't have any control over what happens to it at their death. It will go to their children. So that would be a really tight way to write it. Then another question that we've got to think about is who's going to be the trustee of this trust? Is your spouse going to be the trustee? Is your spouse and maybe a child kind of co-trustees? Sometimes that works, sometimes that doesn't. Like if you have stepmom and stepchild serving together as trustees, sometimes that works and sometimes that's a huge clash. Sometimes people will have a bank or a corporate professional act as trustee. So better assurance that the terms of the trust are respected, don't get dissipated. Those are all things to consider when thinking about, should my spouse inherit in trust? And if they should inherit in trust, what does that trust look like? Well, thank you so much for listening today. If you'd like to learn more about wills and trusts, give us a call. We'd be happy to help you. Our number is 507-252-8997. Thank you.